briefly about this mandatory employment arbitration model. I did describe the voluntary model. The mandatory model that I discussed with the credit card demonstration deserves a little more elaboration. It's been around for at least 180 years and very likely longer. It has its origins in commercial trade. In fact, if you go back to fairs and bazaars that were conducted under the king's authority in England in the 14th century, these were called pie powder courts. But a pie powder court, as I understand it, was a commercial court under the franchise of the king, and it allowed merchants who were there for a day to sell their goods. If they had a dispute, a buyer-seller dispute, you had instant court among neutrals and people who were expert in the ways of that commercial setting. And that's been brought forward since at least that time to a variety of trade situations. And it's reached its fullest expression and elaboration with the securities trading industry. So at this point, members of the New York Stock Exchange and other brokerage exchanges very commonly have to agree to arbitrate any and all disputes that arise among and between themselves. So it's a very familiar kind of situation. The next slide, the next part of the slide that I want to talk about is the Gilmer case. Robert Gilmer was a stockbroker in North Carolina. At the age of 62, he was fired by his employer. He was a high-producing broker, and he alleged that he was discriminated against on the basis of age. So he filed an age discrimination lawsuit. His employer took out the U4 agreement that he had signed when he began his employment and said, Mr. Gilmer, you agreed to submit any kind of dispute, not to a court of law, but to an industry arbitration panel. And sure enough, the United States Supreme Court read that as a binding contract and enforced the agreement. Now, Gilmer made several arguments, one of which was, since there was no bargaining and no conversation about this, it could not be enforced as a contract. He also made the point that Congress, in enacting the age discrimination law, did not mean that individuals could preclude or waive their right to sue. In other words, you would need to make a knowing waiver, a voluntary waiver, and this was not knowing and this was not voluntary. In a 6-3 ruling, the Supreme Court upheld this arbitration clause, and it had tremendous implications for private sector employment. Gilmer was decided in 1991. At that same time, Congress enacted the 1991 Civil Rights Act. And it's worth a moment of our time to talk about it. The 1991 Act grew out of several developments. The catalyst for that law was the confirmation hearing of Clarence Thomas. So we've had Anita Hill and Clarence Thomas back in the news recently. Those of us who can remember back to that time remember that that was a spellbinding kind of few weeks where Anita Hill was testifying. It was a polarizing event in the country. It also prompted many women to come forward and say, I'm experiencing a similar thing in my workplace. Congress enacted a series of amendments, and to make a long story short, A, made it easier for a discrimination plaintiff to prove his or her case, and B, increased damages to include compensatory and punitive damages. A year before, Congress enacted the Americans with Disabilities Act, really a landmark civil rights law. The law was to become effective in 1992. You look at these two acting in combination, the 1991 CRA, the ADA of 1990, and as employers had feared, discrimination lawsuits soared. So these are statistics that come from the administrative office that keeps track of cases before our federal courts. Bear in mind the federal courts are not elected, they are appointed, but in any case, discrimination lawsuits, employment discrimination lawsuits nearly tripled from 8,200 in 1990 to 19,000, or doubled for sure. And then in combination with this, it's important to note, for purposes of talking about my research, by the time we get to the mid-1990s and late 1990s, we have in place a generation of judges selected by Ronald Reagan. A record number of judges who were seated, and by an overwhelming majority, those judges, when they were presented with garden variety disputes involving an employment arbitration agreement, they would rule to enforce the agreement. Not always, but certainly that was the clear trend. So the simple takeaway from this is that courts do enforce employment arbitration agreements. Now, in the 1990s, there was evidence of unequal justice in these private forums. To highlight some of them. In some of these situations, the employer unilaterally selects the arbitrator. A more common method under the voluntary system for selection of arbitrators is a striking method. You get a list of 7, and you strike one, and you strike one, and you go back and forth, and the remaining person becomes the arbitrator. In contrast, under mandatory arbitration, at least some of these, the employer selects the arbitrator. The rules are less generous compared to a court system. Examples: a shorter period for filing a claim. That's a very real concern that I have. When Congress gives you a defined period to file a claim, and the employer contracts that away for you, and that is held against you, that certainly looks like a subversion of legislative intent. There's a denial of certain claims. Just right there in the text it says, all disputes will go to arbitration, fine print paren, except this kind of dispute, that kind of dispute. And I will tell you that many courts have said the exclusion of 1 or 2 kinds of causes of action do not invalidate that kind of arbitration agreement. There's little or no opportunity for the plaintiff to find out information from the employer. So the plaintiff feels like she's trying to fight with her eyes closed or her hands tied behind her back. No class actions are allowed either. Some of these agreements have cost sharing, most unlike a court. The only fee that an individual has to pay is the filing fee. And in most of these discrimination laws, the individual, if she or he can't afford counsel, there's a provision for the winning plaintiff gets attorney's fees. Well, in any event, arbitration agreements are written so that no attorney's fees can be awarded by the arbitrator. No written decision, and if there's no written decision, just a thumbs up, thumbs down, then it becomes very hard for the arbitrator's decision to be reviewed in any meaningful way. So a system began to develop where on the surface it looked like unequal justice. The next small point, but important point to note, is courts review arbitration awards only on a limited basis. They